And welcome back to the Financially Simple Experience. You know, we're on this journey. We're on a journey to try and achieve the 8-figure exit. We've been talking about the 8-figure exit for some time. Look, friends, it is possible. It is possible to experience an 8-figure exit. But along this journey, from wherever you are today to your dream, your aspirations, this 8-figure exit that you as a business owner are yearning for, that you're striving for, that you're working so hard to achieve, there's many things which could disrupt the 8-figure exit. Now, we've been talking specifically to financial advisors, and we're going to continue this journey around financial advisors. But again, if you're not a financial advisor, but yet you are a business owner, today's content is directly applicable to you and your business. I want to take today's topic, which is disclosing litigation during a business sale. And I want to approach it as if you are in the process. You've received an offer. You have somebody who is interested in buying your business. And now you perhaps are head deep into due diligence, which takes a long time to go through due diligence. If we don't handle litigation properly, or if we're not prepared properly for how litigation could harm our 8-figure exit, we may end up wanting. We may end up being far short of our desired outcome. In every business, there's this term that I often use called company-specific risk. Company-specific risk is a risk that is inherently specific to your company, hence the name. However, there's also industry-specific risk. Industry-specific risk. Today, we're talking to financial advisors. And the financial advisory world, it is a highly regulated business. And as such, there are many, many, many industry-specific risk. But perhaps you're not in the financial advisory business. I have a friend of mine who owns a swimming pool company. One risk that he has is what's called floating pools. He would think that a pool wouldn't float, but what happens sometimes is a water table drastically rises underneath the pool and it causes an entire concrete swimming pool to pop out of the ground. It's a industry-specific risk. I have another friend of mine who runs a road construction crew. A very, very real risk to them is automobile traffic and a person being hit by a car. That is an industry-specific risk for road crews. Here in Tennessee, during the summertime and many times during the year on the billboards over the interstate, they'll say, we've had this many road working fatalities. Please slow down. Men are at work or people are at work. That is an industry-specific risk. In the financial space, we're going to talk specifically around litigation because many times the specific risk that we run into in the financial world has to deal with arbitration or litigation or some sort of a complaint, whether it be by a customer or by an employee. You know, the goal is to achieve the 8-figure exit. That is the goal. But current, pending, and past litigation does matter to potential buyers. One of the things that often keep us up at night is the uncertainty that we as business owners face. Now, you in your particular industry, your particular niche, your industry-specific risk or your company-specific risk may keep you up at night. I have a dear friend of mine who's been a client for almost a decade, and one of his past fears before he got out of the business, sold his business, was one of his employees being hit by a car. He wasn't in the road construction crew, but what he did was worked on the side of roads with regards to water lines, fiber optics, things of that nature. And he was always concerned that one of his employees would step out into the road and they would be smashed or hit by a vehicle. It was enough that it would keep him up at night. And as he began approaching his exit, I can remember him saying, man, this is so good. Please, God, please don't let any of my men be hurt. And this time he had all men. Don't let my guys be hurt. It was a specific risk that he was worried about. In the financial space, we are often worried about a customer complaint. Are we doing the right thing for the customer? Are we speaking the same language? Please let us do the best we can for our clients. Let us understand exactly what they need and let us use our minds to help them achieve their desired outcome. You know, litigation has hit the financial space pretty hard. As of July of this year, 2020, there has been roughly 120 M&A deals in the financial space, mergers and acquisition deals in the financial space. So there are a lot of people buying firms. Now, last year in 2022, there was 264 as of July, so not quite as many in 2023 as there was in 2022, but nonetheless, people are buying financial advisory practice. So the 8-figure exit, having somebody buy your firm, is highly possible and probable. But interestingly enough, in 2022, the SEC, Securities and Exchange Commission, did a litigation release. In fact, we'll have a link to it in the show notes and on the blog. But what they disclosed is there had been 306 civil actions against RIA firms or IARs. So RIA stands for Registered Investment Advisor. IAR is an Investment Advisor Representative. So just for those who don't speak the industry language of the financial firm, for your benefit, whenever somebody is registered with the SEC, they are what's called a Registered Investment Advisor. Typically, it's an entity. On the other hand, if you employ somebody who is licensed to conduct securities business, they are a investment advisor representative representing the registered investment advisor. I realize that's technical, but that's the language that the financial world has to deal with. But interestingly enough, on this SEC litigation release from 2022, again, we'll have a link in the show notes, there were 306 civil actions against the RIA, the firm, or their advisors. For 2023, as of the date that we did the research, there were 238. 2023 appears to be a little bit more litigious than past years. So this is a very real problem or concern that many in the financial space face. Interestingly enough, in 2022, FINRA, the Financial Institution Regulatory Association, collected $54.5 million in fines and $26.2 in restitutions. Friends, that's a lot of money. So the very real industry-specific risk, if you're a financial advisor seeking to have an 8-figure exit, has to deal with the industry-specific risk around litigation, customer complaints, etc. You know, whenever you dive into these complaints, these various infractions, these various suits, and civil actions that is recorded on the SEC's website, you'll find that they come in many different shapes and flavors and sizes. It could be negligence. You don't act in the manner that's reasonable to protect the client from a financial risk or harm. It's negligence. A big one is a breach of fiduciary duty. If you do anything that benefits yourself or your company at the expense of an investor. That's a layperson's term for a breach of fiduciary duty. Or breaking the terms of a contract. You know, many times the financial worlds, we try to protect the assets. We end up having employees or our investment advisor representatives sign information to try to protect our proprietary information or try to protect our client list. And sometimes people have their own mind. They go do things that are against the restrictive covenants or the terms of the contract, and that could lead to an action. If we dive a little deeper, though, especially in light of the 8-figure exit, there's two areas that we have to separate. Again, in your own business, if you're not a financial advisor, you probably have something very similar to this. Maybe you're a medical doctor. Maybe you're a lawyer, a CPA. No matter the business, more than likely you have some sort of a litigation issue. In the financial space, we deal with, again, the investment advisor representative. That's the person, the actual person giving the advice. And then you have the registered investment advisor. Oftentimes that is a business or a collection of people giving advice. And so when we're talking about the industry-specific risk of an 8-figure exit for a business owner who owns a financial firm, we have the client-facing risk. We often talk about this through what's called Form U4. Form U4 is a document that discloses the history of individuals. Included in that Form U4, you'll see things like criminal convictions, regulatory actions, civil judicial actions, customer-initiated actions, terminations of employment, bankruptcy proceeding, and so many other things. So we in the financial space understand that what we often term as a clean U4 makes a lot of sense, and many of us take pride in a clean U4. On the other hand, if things happen, and you're in business any length of time, things happen, and perhaps you make a mistake, it will appear on the U4. We did some research into the U4 statistics, and there was a study done by the Investment Advisors Association that did a snapshot in 2022. And here's what their study identified. 16.8% of investment advisor representatives, the actual people, make disclosures on their U4. Almost 17% of financial advisors have some sort of disclosure on their U4. Now, out of those 17%, almost 86% of the disclosures have to do with customer complaints. Customer complaints. In fact, 11.1% of them did. The other has to deal with civil actions. Oftentimes you'll see where, especially back there in 07, 08, and 09, I know some very prominent financial advisors that got into financial trouble. They were leveraged in real estate. Real estate fell. They ended up having to deal with some bankruptcy, and you'll see bankruptcy proceedings on their U4. So we have this industry-specific risk where our financial advisors, our colleagues, our employees for that matter, could have exposure personally that could harm our 8-figure exit. But there's also the business risk. The business risk. You could end up having a civil action against your business. For example, you may have a wrongful termination claim. An employee felt like they were terminated wrongfully. That could end up in a lawsuit. That could end up in an arbitration hearing. That could end up in a civil action. You could end up with a sexual harassment claim, a discrimination, a breach of contract, and many, many, many other types of disclosable actions that your business itself could experience. So as we're talking about this 8-figure exit, and we business owners are striving and we're doing everything we can to reach that particular pinnacle, there are many things that will keep us up at night. Man, I need to let somebody go, but can I do this in a way that I won't get sued? Man, this client's just not quite understanding what they need to do. Can I help them in a way that won't lead to misunderstandings or some sort of a complaint? Man, I've got this particular issue. How do I deal with it in a way that will prevent litigation or civil action from being filed? If we're candid and transparent as business owners, we would all admit that has crossed our minds many times. Maybe you are like the business owner who just concerned, man, keep my guys safe. Don't let a truck come around the corner and hurt one of my men. A very clear and present danger. The reality is, in every business, we will all experience some sort of a disruption, some sort of an unknown that's going to come out of left field, it may feel like. So how do we deal with litigation? How do we deal with past, perhaps present, perhaps pending? How do we deal with litigation during the 8-figure exit? The best advice I was given years ago is to be truthful and transparent. Be truthful and transparent. Oftentimes I see business owners thinking they're going to outsmart the buyers. I can't tell you how many times I see business owners trying to hide the skeletons in the closet, and the buyers will never know. And if I can just get out of the business, sign on the dotted line, get my check, then from that point forward, it's their problem. I've heard that so many times. The reality is anything you attempt to hide from the prospective buyer will be discovered during the due diligence process. Anything you attempt to hide. I don't know about you, but I have 3 kids. I was a child. We've all been a child at some point in our life. But my 3 kids are so much smarter than me. It's like, daddy, who's been on the earth for many decades, doesn't really understand what they're doing. And as they're making their little plans, I can remember back in the day whenever I made my little plans and my dad and my mom just sitting there shaking their head like, son, we know what you're doing. The same is true when it comes to this transition, the exit from our business. No matter how best laid our plans are, they ultimately come to light. So whenever you're considering the 8-figure exit, during the due diligence period, during the time whenever you're asking questions of the buyer and the buyer is asking questions of you, candidly be truthful and transparent. You say, well, Justin, I'm smarter than they are. Maybe you are. Here's the reality. If you act in bad faith, it could lead to a secondary suit from the buyer. Look, friends, this is not the first time for many buyers. They know what's going on. Best thing you can do is you can disclose anything and everything about your business, warts and all, right from the beginning of the process. You say, well, Justin, I think I can hide this particular issue. It's not really a lawsuit yet. It's not really a client complaint yet. Nothing's been filed yet. During the definitive doc stage, which is where you're signing all the documentations, purchase agreements, employment contracts, etc., there's going to be a section called representations and warranties. Representations and warranties. And they are assertions or assurances given by the parties to the agreement. Most of the contracts will have representations and warranties from the seller and the buyer. The seller is verifying the information and all the information has been provided. And the buyer is saying, yes, the information and all the information has been provided. And so more than likely in the purchase agreement, there is a section where you're going to be saying, yes, I have disclosed everything pertinent and important to my particular business, including but not limited to past, pending, or active litigation, complaints, etc. against your company. If you dive deeper into the purchase agreement, there's going to be disclosure schedules. In the disclosure schedules, there's going to be two types. One is going to be a list schedule, and one is going to be an exception schedule. On a list schedule, it's going to list out everything with complete detail on what is being purchased. And on the exception schedule, it's going to list out everything in complete detail on what is not being purchased. So, for example, whenever I sold my company on my exemption schedule, it lists many things, including the ownership and rights to my two books, Your Baby's Ugly and The Ultimate Sale. I did not want any other company owning the rights to my intellectual property that is bound in those books. That's on the exception schedule. On the list schedule, it listed things like computers, if you're in my case, computers, maybe cameras, maybe furniture, maybe equipment, maybe a customer list. So you're going to have two different schedules in your definitive documentation, which is going to list everything that is being purchased and that which is not being purchased. Now, why does that matter? Because if you fail to mention certain actions that cannot be negotiated or indemnified, for example, litigation, then the definitive documents are not going to be held in the purest sense. You could end up having an indemnification issue and ultimately come back and be sued for not disclosing the very facts that you knew of when you signed the agreements. So here's an example. Let's say you were sued as the business owner, not the advisor, but as the business owner. Let's say you were sued by an employee for breach of contract. Whatever the breach was, it doesn't matter. You were sued for $1 million. And now you're trying to sell the business for $10 million. You want your 8-figure exit. It's $10 million, but your employee is saying you owe me $1 million because you breached the contract. If you're open and honest with the buyer about litigation or pending litigation, there's many things that can be done to still help carry the deal through and consummate the deal for your 8-figure exit. So in this case, what may happen is the buyer may say, look, we're going to buy it for $10 million as we agreed, but because you have this pending lawsuit out here for $1 million, we're going to hold back, or we're going to place in escrow $1 million to cover this potential complaint. You're going to get $9 million or the equivalent thereof, but we're going to keep $1 million back. And if this litigation goes away, if the litigation is settled for less than that holdback provision amount, then we'll release the holdback provision amount. The reality is, friends, is this. At some point in our career, we're going to face the threat of litigation, especially as business owners. And if we handle the threat of litigation, whether it be a threat, whether it actually becomes litigation, whether it's past litigation that has now been settled, if we handle it properly, it doesn't have to drastically impact our 8-figure exit. Now, could it? Yes, of course. Every case is specific, but in many cases, if you handle it properly and you disclose it properly and you have the right processes in place, it may not impact your 8-figure exit. So what's the best action steps we can take today? Maybe, just maybe, you're not in the process of the 8-figure exit. The best step you can take is to avoid litigation at all costs. But how do you do that? You create a culture of compliance. Whatever compliance is, whether that be a compliance with some sort of industry standard, whether it be compliance with your processes, with your documentation like your employee manual, your contracts, etc., you create a culture of compliance. Many times, man, I see this all the time. Business owners have this hatred toward, let's say, a compliance officer or the law department, the legal department, and they don't understand that these compliance officers in the legal department, the attorneys, are simply there trying to help preserve the intrinsic value of your company. One of the best things we can do as business owners is to create a culture of compliance. Another thing we can do, especially in the financial space, is adhere to your fiduciary duty. In the financial space, most of us are fiduciaries, which means we have to do what's in the best interest of our clients, put the client's interest above our own interest or the company's interest. If we just simply adhere to that standard, many times we can mitigate any type of risk. I'm reminded of the golden rule: do unto others as you would have them do unto you. Man, it seems to be lost this day, doesn't it? So many times I see business owners with greed as opposed to just simply abiding by grandma's old philosophy of the golden rule. You know, one of the things we can do in the financial space is you can avoid working with high-risk clients or high-risk employees. We've all seen them. Perhaps you're not in the financial space and you have this client or this potential customer that just know they're going to be a handful. You might want to take a hard look at it and say, do I really want to take on the risk for this potential reward? Do I want to take on the risk this client is going to bring me for whatever the reward is, the dollar figure, etc.? So in the financial space, you may avoid working with certain high-risk clients. Another thing you can do presently is work closely with your attorneys and your insurance agents. They're there to help you protect your company. They're there to help you. You can also be diligent in training and supervision. You know, so many times we business owners have so much knowledge in our head. We founded the business perhaps and we've watched it from the ground up, or we bought the business and we've been working diligently to increase the value, and we can see the entire scope as sitting in the owner's seat of the company. And sometimes we make the assumption, we assume, and yes, I realize what assumption means and assume means, we assume that our employees through osmosis just catch what we're trying to do. Friends, that's not the case. We must be diligent. We must be diligent in training and supervising our team members. Another thing you can do at this point is read your contracts. I think it's interesting. Whenever I work with financial advisors, many of them do not know what's in their compliance handbook, the compliance manual. These same individuals who may be business owners don't know what's in their employee handbook. They go to the attorneys or the compliance specialists and they pay for a document. And many times, like these books behind me, they just stick them on the shelf. And they really don't understand what the language is within the documents. Friends, if we just simply as business owners read the governing documents, read the contracts, read the employment agreements, the compliance manuals, the various things which drive our company. If we just simply understand that, read them, and adhere to them, many risks can be mitigated. And finally, another thing you can do to mitigate risk, to mitigate litigation, is to fiercely protect client data from breaches and cyber attacks. You know, we have the honor and privilege. I say that often because I truly believe it within my core being. We have the honor and the privilege of working with so many people who put their trust in us, especially in the financial space. They put their trust in us. They lay their dreams on the table in front of us. We gently grab those dreams and try to help them see how those dreams can become a reality. Whenever people trust us to that level, it's incumbent upon us to protect the confidentiality, the data that our clients have provided to us. You see, friends, the reality is that we can do everything that I just mentioned. We can go in and we can create a culture of compliance. We can adhere to our fiduciary duties. We can avoid working with high-risk clients. We can work closely with our attorneys. We can train and be diligent in supervising our employees. We can know what's in our agreements, all the agreements. We can fiercely do what we can do to manage and protect our clients' data. And in spite of all of our efforts, the best efforts we can lay out, we still may face litigation. We still may face risk as business owners. If we place that reality into light of the 8-figure exit, let me encourage you that just because you're actively facing litigation or just because you potentially are going to be facing litigation doesn't mean that the asset, your business, is not desired by some buyer. It very well could be. But it's incumbent upon us as we're preparing for the 8-figure exit to realize that these company-specific risks and these industry-specific risks can greatly dampen our abilities to achieve the 8-figure exit. I hope this doesn't scare you. I hope it encourages you. I hope it opens up a thought pattern in your head to say, okay, what can I do to protect my business today? What can I do today to add influence to where the 8-figure exit can become the reality? I'm reminded of the old G.I. Joe slogan, and knowing is half the battle. Friends, we know now we've won half the battle. Now we have to go out and apply. We have to go out and do. Hey, if you need help or one-on-one coaching from a business advisor, hey, check out financiallysimple.com, and we'll be sure to connect you with business advisors who can help you in your business. Friends, the 8-figure exit is possible. Y'all go out and make it a great day.